Hello everyone, I'm Jeff Hampton with the Fulgham Law Firm. How to beat a minor in possession charge in Texas. Maybe you or maybe your child has been arrested or charged with minor in possession of alcohol in Texas, and maybe you're here wanting to know, what's the law? Is there a chance that perhaps it could be dropped? What does the prosecutor have to prove? We're going to go over all of those things with you here today. I want to thank you for joining us. If you wait around until the end of this video, I'm also going to give you a free ebook, What to Do If You've Been Charged with a Crime in Texas. Okay, now let's jump into this. Listen, especially at universities, where we're at here in Fort Worth, TCU is literally a stone's throw away from where our office is. And quite frequently we get a lot of calls from freshmen and sophomores here up at TCU. They're underage at the time, but of course they're a part of all the activities that are going on at the university, and they end up getting in trouble and caught in some sort of sting action of Fort Worth Police Department up here, where they end up getting cited for minor in possession or actually arrested sometimes for that charge. So let's talk for a minute about what Texas law first says about this issue. So the Texas Alcoholic Beverage Code prohibits the following activities for those under the age of 21. Purchasing alcohol, attempting to purchase alcohol, consumption of alcohol, possession of alcohol, driving or operating a motor vehicle or watercraft while under the influence of alcohol, and misrepresentation of age as it relates to alcohol. Okay, the law essentially prohibits a minor from making any contact with alcohol at all. Here's some examples of situations where this may apply. Transporting alcohol, of course, consuming alcohol, holding alcohol. These are all things here. Basically, if you're not of the age to be able to drink alcohol, it becomes one of these things where the police are going to have very much a zero tolerance policy on that issue. So while a minor can lawfully be in proximity to someone who is consuming alcohol, he or she must not have what the law calls constructive possession of alcohol. I don't want to beat you down with all of this, but let me give you a couple examples. Let's say you're driving or riding in a vehicle where alcohol is readily available. That's going to be an issue, minor in possession, okay? Sitting at a table where a pitcher of alcohol is available and you're underage and you're not with a parent or a guardian, that's a problem. Gathering empty alcohol containers to discard. Believe it or not, we've seen minors get in trouble for exactly that issue. Holding alcohol for another person. That's the best one of all, right? It's not my alcohol. I'm holding it for someone else. The police will never believe that. They're always going to arrest or cite for that situation. And then using as an alcohol container as some sort of repository for something else. Doesn't matter. The police are going to believe that you were drinking and that you had possessed it. All right. Now, if you or your child has been accused of minor in possession in Texas, it's important that first you understand the law that we just went through. Those are the specific circumstances. But secondly, talk to a very experienced criminal defense attorney, because I'm now going to outline a few exceptions to the minor in possession law and talk a little bit about some of the defenses as it relates to this. Now, four main areas of exceptions that allow a minor to be in the presence of alcohol in Texas. Number one, if the minor is in the visible presence of a parent, legal guardian, or spouse, that this situation will not apply. I'm going to give you the best example of this. TCU football game going on. We ended up representing one of the freshmen that were there, but it was like a parents' weekend. They were all there at the football game, but the Fort Worth PD was walking around looking for anybody that they could to try to, and I don't blame them, they're trying to make sure and keep the peace during the football game. But they see this young man who's underage. He's got alcohol in his hand. Dad is like 50 yards away, running over to another tent to say hi to someone. The police say, "Nah, buddy, you're holding alcohol." He's, "No, it's not even mine. I'm here with my dad. He said I could take a drink." Well, they end up citing him for all of this. We have to fight it. But we were able to show he was within the presence. Literally, when we say visible presence, he could see his dad. The dad walked up to the scene. That was an exception to the MIP. We were able to get the case completely thrown out for that reason. Another exception is possessing alcohol within the scope and course of potential employment, as long as the employer follows regulations. Number 3, a minor is also allowed to purchase or possess alcohol if supervised by a peace officer who is enforcing minor in possession laws. I have no idea where you would find that happen very frequently, but that's one of the exceptions. But then finally, a minor may also be protected from liability if he or she makes a request for emergency medical care for another person who may have overdosed on alcohol. Now, we have seen this happen one time previously. Now, this last scenario, there are 3 stipulations that have to apply. Very rare situation. The minor must have been the first person to make the call for emergency help, and the minor must have remained at the scene until the emergency help arrived, and the minor must also act in full cooperation with all emergency medical workers and law enforcement officers. I mean, it's a crazy scenario, but sometimes you'll have a minor that hangs out with someone who's not a minor. They had way too much to drink, and panic kind of sets in, but yet they're around all this alcohol. That's an exception to where normally being a minor in possession of alcohol right there might cause a problem, but that would fit that scenario, okay? Finally, what are the penalties? Well, listen, being charged with any type of alcohol-related offense, if you have a clean criminal record, is not something you want to keep on your record. You want to make sure it's handled properly. And even though this offense is charged as a Class C misdemeanor, what a lot of people don't realize with a Class C misdemeanor, yes, it's on the same level as a speeding ticket. But number 1, if you just go pay that fine, you're pleading guilty. And it's forever on your record. You can never get it removed, okay? So number 1, do not go just plead guilty to it, all right? It's critical that you don't do that. If you are convicted of minor in possession, you can face a number of penalties. For a first offense, a conviction can result in between 8 and 12 hours of community service or some type of alcohol awareness class. The court system will revoke your driver's license, this minor's driver's license, for 30 days and will also be required to attend alcohol awareness training and make a report after 90 days of treatment, potentially. I mean, this is pretty exhaustive, what could happen to you. Failure to complete the program could result in a further revocation of a driver's license for up to 6 months. And then the first offense, though, so that's the worst case scenario. Let's say you're convicted, right? Well, you might be able to get the case dismissed under one of these exceptions we spoke about if you have a good attorney that's working on your case, or you could also receive deferred disposition. Now, if for some reason you've had more than one of these, if you've had 2 or more previous convictions, you can actually be required to spend up to 180 days in jail and up to a $2,000 fine, and that becomes a more serious offense. And you could also be expected to potentially serve anywhere between 20 to 40 hours of community service and have your license revoked again. So you don't want these to stack up. You don't want these sort of things to line up multiple convictions for something like this. So here's the thing. By the way, parents, if you're listening to this, the other thing that may be a little frustrating to you on this, because it's still seen as a minor, you have to be involved in this process along the way. You literally have to appear with your child in court. You literally have to be responsible for a lot of this process because under the law, they're still seen as a minor and that you have some say over the situation. So my point is this. We all know a lot of underage drinking is going on at universities and other places that are taking place. What you don't want to do is have one mistake define your life and allow that to be something you cannot get off your record. So maybe you or your child are going through a minor in possession charge now. Don't hesitate to contact the Fulgham Law Firm at 817-877-3030. We'd be happy to listen to your specific set of facts and circumstances and give you a free consultation. And I also promised you if you waited around to the end of this video, I'd give you a free ebook, What to Do If You Have Been Charged with a Crime in Texas. Click the link below. We'll send it right over to you. And look forward to seeing you on our next video series. If you like what you heard, subscribe to our YouTube channel. Thanks again for joining us. Take care.